Hello friends, in the series on the income tax cases, today we will discuss a very important case on section 153D. The name of the case is Vrushali Sanjay Shinde versus Deputy Commissioner of Income Tax. This case has been reported in 107 ITR Tribunal, page number 274, and the matter has been decided by Mumbai ITAT F bench, and the date of the judgment is 8th September 2023. As all we know, in income tax proceedings, there is a provision of approval by the higher authorities in a number of cases. Like when the notice under section 148 is issued to the assessee, the approval is required. In the old regime of such cases, in the case of assessment orders under section 153A and 153C, the assessing officer has to take the approval of the range head, that is additional commissioner, before passing the assessment orders. The purpose of these approvals under the Income Tax Act is that so that there is an inbuilt protection to the taxpayer against the unjust exercise of discretion by the assessing officer. It has been seen that the assessing officer are very negligent and they are very hasty and they are very inclined to make the additions which do not deserve in the eyes of the law. But at the same time, it has also been noted in the number of cases that even the approvals have now become a ritual, and the range heads or the higher officers of the department give the approvals in a very mechanical manner, without application of mind and without deriving the satisfaction whatever have been produced before them by the assessing officers. This case is a perfect example of this thing. In this case, the assessment of the assessee was completed under section 153C by making huge additions and after taking the approval from the additional commissioner. When the assessee was before the CIT appeal gave relief to the assessee partially. So both the department and the assessee was before the ITAT in cross appeals. The assessee raised an additional ground before the ITAT regarding the mechanical approval of the additional commissioner under section 153D. The ITAT allowed the additional ground of the assessee because that is going into the root of the matter, and that is also a technical ground and a legal ground. There is a rule that whenever there is an additional legal ground or the technical ground, it can be entertained at any stage. So the ITAT allowed the additional ground of the assessee and said that in the present case, whatever the approval has been given by the additional commissioner is a very mechanical approval. In the present case, the department has given the affidavit before the ITAT that the additional commissioner has guided the income tax officer from time to time in the assessment proceedings. The ITAT said regarding this affidavit that this is an afterthought of the revenue. The ITAT also said that in the present case, whatever the approval memo has been made and shown to the additional commissioner for taking their approval, it is clear from the approval memo that no satisfaction has been derived and there is non-application of mind in giving the approval. Friends, approval means that the assessment order has been duly read by the additional commissioner, by the joint commissioner or by the range head, and whatever the inputs are there, he has given. But we have seen that whatever the approvals are given, whenever the draft assessment orders are made, they are just passed by as a rubber stamp by the higher officials, due to which the assessee has to face the burn of various huge additions. And when these additions go into the CIT appeal, the assessee has to face the heat of high demands also, penalties also. So the assessee got stuck into the litigation circle. So in the present case, the ITAT came to the conclusion that whatever the approval has been given It is just a ritual. It is given very mechanically without application of mind. And the ITAT quashed the assessment order on this ground alone. At the end of this video, once again I am repeating the name of the case. The name of the case is Vrushali Sanjay Shinde versus Deputy Commissioner of Income Tax, and this case has been reported in 107 ITR at page number 274. The matter has been decided by Mumbai ITAT and the date of the judgment is 8th September 2023. Thank you, friends.